Hey out there, I'm Paul Ravelli, and in this video we're going to talk about the fourth of 8 ways that parents leave an inheritance to their kids. Got to mention today is Thanksgiving Day, and so I took a little break from the Thanksgiving preparations we're having. My wife and I, we got 5 kids, and they're all grown up now, and so they're coming back, kind of a big meal, some extended family. Took a little break from that to share some, create this video because I said I'd do one every day for 8 days. All right, let's jump right in. In part 1, it was about the lifetime gift. Part 2, the outright bequest. Part 3, leaving an inheritance to a child with your child as the trustee. And this fourth one's really popular for a couple of different reasons. So it's the parents leaving an inheritance to their child, but they're leaving it to them in a trust, and the child is not the sole trustee of that trust. So let me go over how that's done, then we'll go through the reasons people do it, and then we'll go through the consequences, and then we'll wrap it up. I got to get back to Thanksgiving preparations. All right, how it's done. It's done essentially one of 2 ways. Either in your will will say something like, when I pass away, or after my spouse and I pass away, whichever is appropriate, I leave 1/4 of my estate because I have 4 children, 20% of my estate because that's the percentage that you want this person to get. I leave this amount in trust for my child, and amongst the many trust provisions, your child will not be designated as the sole trustee of that trust. That's done through your will. That's called a testamentary trust. The other way to do it is if you're wanting to avoid probate and you have your revocable living trust. In your revocable living trust, you can say when you and your spouse, whichever applicable, pass away, assets go to a trust for your child, and your child's not the trustee. There'll be a lot of other trust terms as well. Okay, so that's how you do it. The reasons, now, well, let me get back to that. If your child is not the sole trustee of that trust, who is the trustee? So it could be maybe, and we'll get into some of the reasons for this, it could be maybe your spouse and somebody else together as co-trustees, and it takes both of them to act to get something done or to take an action as a trustee. It may be just another family member or a trusted friend or a trusted colleague. And in certain circumstances, it can be even a corporate trustee. And those circumstances usually include there's a lot of money involved. Corporate trustees won't get involved unless they're managing a trust that has a lot of money. A lot of money is a relative term, but every corporate trustee is different. And so the reasons people do that, well, there's several. One of the reasons people leave things to a trust for their child and their child is not the trustee is if they need to protect the child from themselves. So an obvious circumstance like that is a minor. So if you're leaving assets to a minor, you need to leave it in trust and name somebody else other than the minor as the trustee of that trust. That one's a no-brainer. I think everybody pretty much understands that. But also when we talk about the protect them from themselves discussion, we often, and we have that discussion a lot because we live in a crazy world, and some people have children who are on drugs, they've been in jail, they just flat out can't handle money. And so it would harm your child if you just left them a lump sum of money or proceeds of a sale of your home after you die, or life insurance or IRA or whatever. So when we talk about protecting your child from themselves, perhaps even the adult child over 18, but they just can't handle money responsibly. So very common for parents to leave those assets to a trust and name someone other than the child as the trustee. Also, another reason people do this is so that the child doesn't get influenced by their spouse or somebody else. So I've had more than a handful of people tell me something like, well, Paul, I want to leave money to my son, and I know if I left it to him, he'd do the right thing, but he's married to this woman, and she completely controls him, and she spends money like crazy. So I know what would happen if I just leave money to my son. He'll want to do the right thing, and he'll want to save it and use it for the right reasons and really give him a cushion for his retirement. But his wife ain't going to let him. So we need to put his inheritance in a trust, and we can't name our son as the trustee of that trust because his wife will influence him to take those actions and go spend it. So let's name maybe our son and our daughter as co-trustees, and then the son's wife, influencing your son or her husband. He can't do things by himself. It takes both of those trustees to act. Now, maybe you don't want to do that to your daughter, or maybe your daughter doesn't want you to do that to her. So all these family dynamics play a role in it. But sometimes naming the child and someone else as a co-trustee can prevent that influence. It also could create some friction after you pass away. But so those are things we got to talk about. So maybe you don't even name your child as a co-trustee. You just name a third party as the trustee. And again, same reason. If you're worried about your child, and some grandparents are worried that if they leave money to a child, their grandchildren will influence the child into doing the wrong things. We already mentioned the concern about the child's spouse influencing the child to do the wrong thing. So those are some of the other reasons besides protecting the child from themselves. You may have a very responsible child who just gets influenced by a certain person or certain people, and so you just can't afford to put that child in control because you'll know they'll be influenced. So that's another not as common reason, but happens. All right, so what are the consequences of leaving money to a child this way? Well, the practical consequence is the child's not going to be able to get at the money by themselves. If they need it, they're going to have to go to another trustee who's controlling their inheritance, or that co-trustee, whatever the fact may be, and get approval to use the trust principle for something that the child might need, assuming the trust instrument authorizes trust principle to be used for the child. Now, there's some divorce protection in there as well. So as long as those assets sit in the trust, they're not commingled with assets the child has with their spouse. If the child gets divorced, he keeps his trust. Child and spouse split other things they've acquired, so that's not bad. And then also, when you name a third party as the trustee, you're likely to give your child some lawsuit protection or some creditor protection. So if your child has incurred a bunch of debts or has, creditor or lawsuit issues, and which in these days it happens often, leaving assets to a trust for your child where your child can't get at them by his or herself is likely to give your child some lawsuit or creditor protection. Other provisions of the trust instrument may also play a role, in that lawsuit protection as well. The designation of who is the trustee is not the only factor that determines whether a child's trust is exempt from the creditor claims against the child. So here in summary, this is a really popular scenario: parents leaving assets to a child in trust, and the child is not the sole trustee. For reasons mainly three. One is the child or grandchild that you're leaving assets to is a minor, and a minor can't be a trustee. So you'll name another trustee. Second reason is you're wanting to protect the child from themselves. Child's just not responsible. Child couldn't handle money. You may be doing more harm than good by leaving it to a child outright, so it needs to go in a trust with somebody else as the trustee. And then the third reason people leave things to a trust for a child but don't permit the child to be the trustee is if you had left assets to a child outright or in trust with the child as the trustee, there may be another person, child spouse, for example, who would exert too much influence over your child and influence them to do things that you would not intend, or maybe the child would not even do if that influence was not there. So I hope that gives you some guidance as to when it's appropriate to set up your estate planning program to leave assets to a trust for your child And of course, someone other than your child is the trustee, or at least a co-trustee with your child. It is Thanksgiving today. I'm going to go back to preparations. I do in the comments below want you to answer the really important question, what's your favorite Thanksgiving dish? And as I'm asking the question, I'm trying to figure out what mine is. Oh, it's a tough one, but mine is what I do. I cook on my big green egg. It's some pork loin stuffed with cream cheese and jalapeno and wrapped in bacon. I do that every year. It's kind of my thing. So what's yours? Put in the comments below what's your favorite Thanksgiving dish, because I'm recording this on Thanksgiving Day. Gonna do 4 more over the next 4 consecutive days, how to leave it to your kids. I really think before you put a serious program in place, I think you need to understand all of the different 8 ways that you can leave things to a child so you can make an informed decision. I'm Paul Rabelais. Make sure you subscribe, hit the notification bell, thumbs up. Happy Thanksgiving. Y'all have a great day. See ya.